I've seen a lot of sort of discussion, right? A lot of debate among attorneys in terms of how much evidence do you really want to put forth? How do you feel about that? Where do you stand in terms of your experience?
That's a fantastic and $1 million question. I think if I had a perfect answer to that, I would have a 100% approval rate with USCIS. But I do think it's an interesting question, and what I have learned from my experience, and I think my preferred approach is what I would kind of think of as like the Goldilocks approach. So somewhere just right in the middle. I understand the argument for submitting a really, really concise petition, and I think it has some merit. My concern, though, is that if one errs too far on the side of this sort of brief and concise petition, that the officer may issue an RFE sort of saying, well, you didn't document, like you just submitted the first page of a publication, but you didn't submit anything else about that publication.
Right.
On the other hand, if we write a 120-page legal brief and we have 900 pages of evidence
Right.
and documentation,
Right.
is there, sometimes a hopeful chance that like the officer is impressed by the size of the kind of petition on their desk and they just approve it because they want to sort of, not read it? I know that I think some practitioners and some clients hope that that's the case. Because I sort of feel slightly unsure about both of those extreme approaches, I try to kind of fall a little bit in the middle. And I think there's two strategic reasons for that. One is based on kind of those two extremes we just talked about, in the sense that don't really want to like write a brief that's so concise that the officer thinks, the candidate must not be qualified. But we also don't want to overwhelm them when our best guess is that most immigration officers have 15 to 30 minutes to review each of these.
Right.
What I sometimes like to do is sort of include most, if not all, of the documentation and aim for a sort of more concise, or at least more pared back on the legal brief, because that's where they're going to kind of focus. And then they can go to the evidence if they want to. And I think this has two advantages. One, if, it's sort of like plays to both the officer that's going to read this in 5 minutes and the officer that's going to spend 30 or 45 minutes, and they have everything that they need to see there. I think the other thing is, if we do receive an RFE, and it's important to remember that requests for evidence, unfortunately, are sort of a little bit of a matter of luck in EB-1 in particular adjudication. Maybe 20-25% of cases might get them regardless of the strength of the case.
Right.
This sort of approach of holding a little bit back in our evidence quiver, so to speak, means that we have something to come back at the officer with, whether that's because there was evidence in the evidence that packet that we touched on but didn't fully explore, or even potentially we saved a few media articles or saved a few scholarly publications back. It gives us something to push back with, so that we're not just responding to a request for evidence with a sort of slightly legalized regurgitation of the original brief. And I think that that's given, me, in my experience, that's given us the optimal way of sort of handling this sort of conundrum of how much evidence to present USCIS with.
Extremely interesting, and like I said, I mean, there's two different sort of sides that are constantly battling that out. I've heard a ton of attorneys in these chats saying, "What are you doing? You're just wasting paper." The other side is like, "What are you doing? You're not being doing your duty right to your client by submitting as much evidence as possible." But it's certainly, I tend to agree with you that so as most things in life, right in the middle is typically the best way to approach these things.